Today my topic is the IPR and technology management in agriculture. So before we start with the detail of the IPR in agriculture, basically I would like to focus on the issues of IPR in agriculture basically, and because this IPR issues were basically started after the Paris Convention in 1883, where it was it was basically for the protection of industrial research, industrial properties, where this agriculture was envisaged as an area of enterprise in respect of which the property rights could be secured. So basically, at that time, it was the trademark. Trademark was basically taken as a IP, and it was
Sorry, sir,
protected.
for the interruption.
Yeah,
Sir, can we go in
please.
the slideshow mode?
Yes. Is it okay?
Yes,
Is it
sir.
okay? Yeah. So so before enter into the IPR, what is IPR and how what are the different forms of IPR and how it was applicable in agriculture basically, because as I said this the journey of IPR basically started when we are talking about the global perspective of IPR. It was started from the Paris Convention when it was established for the protection of basically industrial property, where it was the protected for trademark. It was protected for trademark. Then the first attempt for the IPR basically of plant breeders. Plant breeder was enactment of the Plant Patent Act in 1913 USA, and that was the first the attempt of to recognize the basically IPR in plant breeding. Okay, so after that, up to 1970, and this the IPR was basically established in the field of agriculture when it was well established in the developed world, and that IP protection will be extended to the agriculture. That was the discussion at that time, and then several the acts or the laws enforced and all over the world where these IP protections were even clearly defined and protected in all the respective laws in the different countries. So before starting, what is IPR? When we are talking about the IPR, it is basically the intellect of a creator, intellect of a human mind, which is giving in the an creation. And if that your creation is in mind, that is in an intangible form, and your creation converted into the property in the physical form, that is the tangible form, it becomes the property. And the rights which are given by the government or the state for your IP, for your invention which you have created in the whether it is the scientific or the artistic or in the industry related. So these all kind of IP, different forms of the IP, which is the creation of innovator or the scientist or the researcher, and that is protected under a certain law in a defined law of a state or the government of a country. So the rights are given under a certain law. So IPR is basically the legal rights and are conferred by the state to the owner, to the creator, to the innovator who is giving the intellectual property. So and here basically it is given in a certain jurisdiction and for a particular period, and where this all rights are given to the innovator or the creator to exclude others to utilize their or his or her property, right, without his without his permission. So nobody can use any IP which is created by somebody and it is protected under certain law, and without it or her permission, I mean the creator's permission is required to utilize that kind of IP. Then these are the different features of IPR, and the general features of IPR. When we are going to create an IP and want to protect our IP in a certain law, that these features must be there. Basically, in IPR, these statutory rights are given to a particular innovator for a particular IP. So these are the statutory rights, and then it is given in a particular area, particular region, or particular country, that is the territorial in nature, and it gives the monopoly to the right holder, right? Who's the right holder? Is the creator is the right holder, or the innovator is the right holder, who can give his IP to exploit from the perspective of commercialization. So it means any IP, if you are going to protect, that must have some commercial value, I mean economical value. If it doesn't have any economic value, it will not be able to protect under certain IP law. So it must be have some the economic value. It must be commercializable, and then enable, we have to exclude the holders to exclude other from the unauthorized utilization of your IP. And then it is given for a limited period. In case of the patent, it is given for 20 years, right? And for the plant varieties, in case in our country, it is given for for the field crops. If we are going to protect some varieties in the field crops, I will discuss in my subsequent slides and the detail about the PPVFR law and what are the different the important laws which are required for IP protection in our country. And then it is given for the limited period, 15 years for the plant varieties, and patents for 20 years, and it provides rights to the prospect, right, for the future. And it requires disclosure. You have to, if you are going to protect your IP in a certain law, you have to disclose some information which is required for protection of that particular IP which you have generated, which you have developed. And these are the different areas which we are, different research results which we are developing, which we are generating in our day-to-day activities, in our because we all are the researchers over here, and we generally do the work in our lab or the field, or whatever the kind of work you are involved, that the different kind of inventions, that may be the new technology or more modified or adapted technology, or the product or the processes. It may be your biological resources like varieties, or the hybrids, and the different kind of different assets. These are basically the intellectual assets which we generally produce in our research results, out of the research result. And then different database also we usually produce after our experiments. From our experiments, research experiments, we generally find some data, and what kind of data can be protected, through which kind of IP it can be protected. That is the different aspect. And then the last one is the core competency, that is the professional services, which is basically being provided by innovator or the scientist or any researcher, who are having some kind of experience or expertise in their domain, in their area of research, or in the area of your expertise. And you are, somebody is asking to provide some consultancy kind of things, contract search or contract service, by utilizing your experiences, you may provide. That is also in your intellect. Basically, that is also your intellectual property. This is in basically in the intangible form. So these are the different international IP, the related treaties or the policies which were formulated over the time when this IPR regime came into force in our country. And of course, all over the world. I mean, if we talk about, from the global perspective, then, the first time this agriculture, in the field of agriculture, this IP protection was started by enforcing this US patent law, that was the Plant Patent Act by US in 1930. And then this journey was started after the international, the Union for Protection of Plant Varieties, that was the UPO. And this was basically very important convention where the different, the member countries were there. Of course, India was not a member of this, the UPO, But of course, we have taken some the guiding principles from their from their policies. So convention basically started for, it was for the protection of plant varieties, how plant varieties as an intellectual of breeder or the plant breeder or the farmer can be protected, and what should be the guidelines. So these discussions were initiated when this UPOP convention was established. And then the FAO has established an international undertaking on plant genetic resources, where the human mankind generated the all kind of germplasm. It was freely exchanged. There was no defined the rules and regulations for exchanging of the material, but they were talking about the breeders and farmers rights. They were taking the interest of the breeders and farmers, who are the contributor for development of the varieties. So for the development of varieties, so these issues were discussed at the international forum when this undertaking was enforced. And then in the deep negotiations in the different countries, the attention was given on the agriculture. It was the focus on agriculture, trade, and domestic policies, where many discussions were there to avoid the monopoly on the different commodities, particularly in the plant varieties in the market. So based on that, all this, the Convention on Biological Diversity was also established, and this was basically formulated in 1992. And then India was a member of the CVD, and where it was the main objective of this CVD was the conservation of plant genetic resources and sustainable utilization of plant genetic resources of bioresources, and the fair and equitable sharing of benefits out of the utilization of plant genetic resources. So these discussions were there. And then the 1995, and this WTO agreement, that was on the TRIPS agreement for the protection of plant varieties by patent, or I mean a member country. This TRIPS were basically the regulation guidelines for the protection of plant varieties, and it was the regular agreement where the all the WTO member countries, like India was also a member of WTO, and we had all member countries had to follow the guidelines. They set some the minimum standards for the protection of plant varieties, and they have taken the issues, or the all the issues of protection of plant varieties by either by patent or by effective sui generis system. Means sui generis system means it is literally mean of its own kind or the unique. I mean, member country can develop their own law depending on their requirement. So India basically by following this sui generis system, India developed our national own law, that was the Protection of Plant Variety and Farmers' Rights Act in 2001. I will discuss in my coming slides. And or the combination thereof. I mean, this was the freedom for all the member countries. They have to develop, but they have to develop the law for protection of plant varieties. So then the international treaty was IUPZR, basically the renegotiated in the form of international treaty on plants and resources for food and agriculture, for the multilateral exchange of the genetic material, and it was basically giving the facilitation for access of genetic material and the transfer of genetic material under multilateral system. As we know, the different the crops, what are the crops can be freely exchanged, that the Annex 1 crops, which were decided in the international treaty, that is also called the sea treaty. And then the last was the Nagoya Protocol, which is basically the requirement of all the conventions, all the treaties, that farmers' rights must be protected, and the means the rights of the providers and users must be protected. And then the providers should also get some benefit, the fair and access, the access of genetic material and the fair fair and equitable utilization of the benefit sharing coming out of the utilization of plant genetic resources. So that based on that aspect, actually this Nagoya Protocol was set, and it was the requirement of CVD. And here both the interest of the providers and users for the genetic resources have been taken care of. And this is basically I have shown here in the in some the dramatic form. I mean, you can I have drawn over here. You can easily understand what is the plant biodiversity or diversity interface, which is basically approach to balancing the rights of the providers and users. And here, as I have already mentioned, I will not repeat here, the International Union for undertaking on the plant genetic resources. It was, before that, it was freely exchange of genetic material. There was no control. That's why this international undertaking was set in 1983 for common heritage of mankind and for the access of plant genetic resources. And then the Convention of Biological Diversity, it was came into force in 1993, where basically the all the member countries of this CVD, they are free to take to protect their rights for the conservation in sustainable utilization and equitable benefit sharing out of the access of plant genetic resources. So these were the issues were discussed in these different kind of the international conventions, and basically the policy guidelines were given by these policies, these international agreements or the policies like TRIPS. TRIPS was basically mandatory. It has mandatory requirement for protection of plant varieties based on these requirements, because all these plants and animals and other microorganisms were excluded from the kind of patents, because in the patent law in 1970 it was also excluding these the plants or animals. So there was no provision, there was no law for taking interest or taking protection of plant varieties. Then the India took some the guidelines from the TRIPS and the EPOP, and our own law we developed, that was the Protection of Plant Variety and Farmers' Rights Act, where we have taken care of all the interest of the plant breeder, farmers, and researchers' rights. I would like to explain in my subsequent slides. And then based on the CVD guidelines, the CVD provisions, we developed our Biological Diversity Act, that was for the 2002. It was basically to regulate the access of plant genetic resources. So all these, the international treaties we followed for, conservation, sustainable utilization of plant genetic resources, and access of genetic material, and the protection of plant varieties, farmers' rights, and then the rights of the, the conserver and or the provider and user both. So all these things were taken care of. Being India being member of these international treaties or conventions, we also developed our law. And these were different in the relevant laws in agriculture. Basically, when we are talking about IPR, we must know about these laws, because here I would like to mention here that the Seed Act 1966, but this is not an IPR law. However, it is very, very much essential to require the knowledge of this, this law when we are talking about the protection of plant varieties under different law in our country in a PPBFRA. So this is basically regulates the production of the quality seed and distribution and quality seed of the varieties, different varieties. And then this law is giving, regulating the, provisions for giving the quality seed. Then PPBFRA has also included that kind of, the provision, how to regulate that quality seed production, right, by the different organizations, by the public or the private sector. So that kind of, the points we are already taken up in the PPBFRA. When we are talking about IPR law, we must know the Seed Act also, because all the, the varieties, whatever the varieties released, notified under this law, section 5, that are being considered as extant varieties or the new varieties in this PPBFRA. So that's why it is required to have some, the sense over the Seed Act. Then the Indian Patent Act, as we all know, this very old law that was established in 1970, which basically giving to the innovator or the creator, who is giving the IP, I mean as a patent, I mean this right is given to the creator to exclude others, and he or she is having all the right to utilize their IP. Well, or they want to, if they don't want to allow to utilize by other, they have all such kind of rights, and this is given for a certain period. It is given for 20 years in India. And then PPFRA, basically the right to produce, sell, market, distribute, import, or export the registered variety of all notified crop species. I mean, under this law, there are more than 200 crop species have been notified. Under these notified crops, where all these kind of guidelines have been well established, under these notified crops, these different kind of the varieties are being protected under this law. Those kind of varieties, I will explain what kind of varieties are being taken up. And then the all the rights, or the rights of the farmers, breeder, or the researchers have taken care of in this law. And they are having, I mean, this law is having the provisions of benefit sharing out of utilization of the varieties. I mean, as a source of plant genetic material. I mean, the person, the farmer is, suppose a farmer is providing plant genetic material, and that genetic material is being utilized as a parent for developing a new variety. And then there is a provision for giving the benefit sharing, sharing of benefit accrued out of the utilization of that particular variety or the genetic material. And there is a provision of recognition and award to the farmers who are the conserver, who are provider of genetic material. So there is a provision of that also. And because all these kind of we here, I mean, we can correlate that all these Biological Diversity Act related and conservation of plant genetic resources kind of the provisions also included. So all these laws basically are the interrelated to protect the plant varieties and providers, to protect the interest of the providers and users, right? And then the geographical indications, because the indigenous indigenous people who are providing the geographical indications and the traditional knowledge, or the geographical indications where the particular good is giving a particular taste or the quality in a particular region, and that good is protected under geographic indications of goods law that was enacted in 1999, and rules were formulated in 2002. And then another important law is the Biological Diversity Act, as I already mentioned. I will not repeat, and because this is giving basically the conservation and sustainable utilization and benefit sharing of utilization of plant genetic resources. And these are the different, the minimum standards which were given under UPOV or the TRIPS for the development of IPR laws for protection of plant varieties, and even the patents. Because in the patent law also some modifications, and patent law was also developed based on the provisions of the this TRIPS, or the WTO giving the TRIPS agreement. In those in that agreement, there were certain the provisions where these provisions every member country has to follow. And then the copyright, trademark, registered and industrial design, all these different IPR law were developed by the different member countries of WTO. And this UPO basically focus on protection of plant varieties, new plant varieties. And that is basically initially it was given for plant breeders' rights, protection of plant breeders' rights. And this is a patent. What is the patent? This is basically the legal monopoly right granted to an inventor for an invention in the return for the disclosure of invention. And basically this is the criteria for getting any patent on any innovation or the product or the process. Basically the product or process are being protected under patent. It must be a novel, it must be a product that is new, that must be new, or it should be reproducible. It involves inventive steps, non-obvious it must be, and it should have economic value. It should be applicable for industrial utilization, means commercial value. It must have some commercial value. And there are certain sections where our agriculture, methods and certain, these methods which are utilized in the agriculture, in the field of agriculture, are not protectable. So under section 3 and 4 have defined for the non-patentable subject matters. So basically, this is giving the exclusive right is given to the inventor, because here inventor is solely owner of his or her invention, or who can apply, who can give, you can allow to other, or he or she does not want to give any permission to utilize these their inventions. That is solely depend on, actually that's why it is, the exclusive right is given to the inventor. And these are the non-patentable subject matter. As I mentioned, when we are talking about agriculture, then these were the non-patentable subject matters in the patent. That's why we developed, the Protection of Plant Variety Farmers' Rights Act, because plants were not patentable. Animals in a whole or the part of their microorganisms, these were not patentable. Seed and varieties, species, and essential biological processes, even for producing plants like tissue culture process, these were not patentable, right? So then traditional knowledge or aggregation or the duplication of known property of traditional knowledge, it was also not allowed in the to protect in this law. Then method of horticulture and agriculture. Then we, that's why, I mean, we have initiated this because this protection of plant varieties were very much required to protect under certain law. Then these are the different challenges, because when you are going to protect your innovation, which is related to the information of genetic material or the biological resources, which is, available in our nature, and then you have to, follow the guidelines of NBA. You require permission of NBA when you are going to file an, to get an IPR on your, research results. You have generated the IP, and now you want to get patent on your IP, that research results are related to your biological resources, then definitely you have to go for NBA permission. Means they will give you the, before granting the patent based on the information of biological resources, any kind of patent or any kind of innovation, they require, the patent office will give you a form to, get permission from the NBA. I mean, they will take the signature or the approval of NBA. You have to follow those kind of the guidelines. So these are basically the challenges. And then you have to disclose the, or the filling of the sequence listing of the nucleotide. If you are supposed, you are your research results are based on the DNA, and in the gene construct, then this kind of some difficulties basically people feel. And then the disclosure of geographical origin, and now you are utilizing a genetic material in your research, and now and you don't know the background of your origin of that particular material, and that is also basically required. So this is geographical origin of biological material which is being utilized in research results in your experiment, and based on those experiments, now you are going to take patent. Then this kind of information is required. Then disclosure of name and address of depository. I mean, we have the five national bureaus. Five national bureaus all are recognized by this, NBA. And now, if you want to, take to protect your invention as a patent or the process or product, they will also ask to deposit you the material of that material which you have utilized, material in the repository of NBP, and like in the case of the plants, it is an NB, it's the NBPGR. In case of fish, NBFGR, and animal, in case of NB and animals, NBAGR, lifeline. So we have the different five bureaus which are taking care of all these the materials. And then the opportunities, basically the various startups, various entrepreneurs are coming up, and they are also allowed to get protection of their process or the products or different kind of technologies to protect under this as a patent, to take patent. And then applicant is the small entity, can be, and a whole entity can be utilized for a patent, or an government institution, or government organization can also apply for taking patent. So this this kind of provisions are given. And this is basically the how, I mean, as I mentioned in my the previous slides, the based on the TRIPS agreement, the provisions of the TRIPS agreement, there was a provision that either member country has to take care all these breeders or the farmers' rights to protect their varieties as a patent or an effective sui generis system or any combination thereof. I mean, there was a freedom to take, kind of provisions to formulate the law in their respective countries. So based on this sui generis system, because for own kind or the unique law, because that's why our PPVFRA is an unique law in the world, right? Because we have included the provisions or we have taken care of interest of the farmers, breeders, and researchers, and even industry, right? I will explain here. And this is the statutory organ of the protection of PPVFRA, and there is authority and registry. Authority is taking care of all these rules and regulations, and registry is protecting and giving the certificate for as a to register different kind of varieties. And this sui generis system we have adopted, and it was enacted in 2001. And basically the contribution of farmers and agrobiodiversity conservation and farmers' rights were also taken care. And these are the different objectives of this PPVFRA, because PPVFRA, this is basically supporting and taking care of all the plant varieties for protection and the rights of the farmers and the breeders, as I mentioned, and then the rights of the farmers in respect of their contribution made to development of new varieties. They are contributors because they are the contributor for the plant genetic resources for development of new varieties. So that kind of, the provisions are also there to give them the benefit sharing kind of things, for because they are contributing for development of variety. And then the plant breeders' rights to stimulate investment. Basically, when we are developing a variety as a breeder, basically it gives it induce the investment for the research and development of new varieties in the private sector as well as in the public sector. And it also gives the growth of the seed industry to ensure the availability of high quality seed and planting material, because there is a provision if some kind of variety which is being licensed to the private industry, they have to ensure that the quality seed and the quality and quantity of that particular seed is required in the country have to supply. So those kind of the provisions to the licensee is also given. Suppose one breeder is going to give his or her variety to license to some private industry, then private industry has to ensure this the availability of the quality and quantity of the particular variety seed. And this is basically the interrelated all these interests have been taken care of. And this initially the rules was formulated for this PPVFR in 2003. It was established, authority was established in 2005. And the initially it was started with 12 crop species, where the notification of 2006 of it was given for 12 varieties. The extant varieties initially was submitted. Extant varieties I will explain. These are the basically the release notified varieties or the variety for common knowledge or the farmers variety, which are notified. And these varieties can be taken as an extant variety. And the new variety I will also tell, the variety seed has not been commercialized before 1 year, and that is taken as a new variety and farmers variety, as you know. Then registration of crop varieties was started in 2007, because in 2006 these were deposited, these varieties, and registration was started in 2007. So this is a little bit history of this PPPFRA. And this is the basically process. And when you are going to submit a variety to protect under PPPFRA, you will fill up the application, submit the application, and examiner will examine your application if the publication, and they will publish in their plant variety journal of India to to give the information, whatever the information they have asked for protecting your variety. And then they will put this information in public domain to take some opposition. If somebody wants to be say that no, this variety was developed by me before that particular person. So if he or she is claiming like that, or that opposition will come, and there is a set pro forma or the set procedure to give the opposition for particular variety which is going to taken up as a as a protection. I mean they are going to provide that variety to protect in their law, and before examining this kind of information they basically put in public domain to get, if somebody is opposing kind of opposition comes, then they have some certain different set procedure, set steps one has to follow that. And if opposition be upheld, then proposal will be rejected. Otherwise, this the no opposition is coming for a particular variety, then examination will start based on the endus new this the novel or distinguished uniformity and stability test that will be taken up by the authority with the different centers. And when this variety is pass through this endus test, then it will be applicable to that variety can be protected under this law. And then there is a provision of an annual fee for renewal of your variety. I mean, initially they give the 6 years for the field crops, then 9 years for the extension. So to altogether, 15 years protection is given in this. And then there is a provision for renewal of fee. Then compulsory license that I have a little bit mentioned, that if the license is given a particular industry and industry is not able to provide the quality and quantity of particular seed into the farmers, then there is a provision to disagree with the agreement, and they can give to other companies. So that kind of provision is also given. And then benefit sharing, also there is a provision, a revocation and surrender. This is for important, the steps for continuing, because for continuity in the crop variety improvement, the researchers are also involved. So they have taken care of all the researchers' rights for, like the utilization of genetic material as one of the parents to development for development of new variety. So there is no need to take authorization of the breeder, but if that particular variety is required for repeated use for of that particular variety parent for development of new variety for commercial purpose, for commercialization, like in case of hybrids, or in the development of a, suppose if you have a variety, you have developed a variety and one of the parents you have utilized from somebody's research, you have, and now you want to commercialize that variety, you have to repeat for repeated use of that particular parent, you have to take permission of that protected variety of the breeder. So safeguard to earlier the crop variety base of the research infrastructure, like extant variety, because we have already notified, developed, released, those kind of varieties are also being taken care of to protect. And essential draft variety, the variety which is bred for a particular distinguished for a particular trait which is different from the previous variety, I mean as a candidate variety. And authorization for repeated use of that particular variety is also required when you are going to commercialize. And there is a provision for farmers' rights. Farmers can save or use or sow or resow or exchange their the protected variety seed. Any protected variety they can take, they can save or resow, sow or exchange or share or sell or produce, including seed of protected variety. But they cannot sell the branded seed. They cannot put their brand on that particular seed of the variety. And there is a provision of benefit sharing and compulsory license. As I've already mentioned, these are the different kind of varieties which are being protected under this law. Novelty, I mean, it must have new variety, it must be a novel. How we can define it is a novel? At the date of filing of application for registration for the protection, the propagated material or the seed of such variety has not been sold, that you have to ensure. So for 1 year in outside within India and outside India, it is for tree and vines earlier than 6 years. In any other case, 4 years. And it must be a distinct, uniform, and stable. The variety must be stable. And then extant variety, as I mentioned, already mentioned. Then essential derived variety, as I have already mentioned, it is basically the variety derived from such initial source of the variety, which is clearly distinguishable and confirmed except for the differences which result from act of derivation for a particular trait, which you are going to develop that variety. So that must be called as an essential variety, and that essential characters must be expressed, right? And then the farmer traditionally cultivated variety, which is evolved by the farmer and is what related of the land races of the variety, about which the farmers have common knowledge. And these are the dust testing criteria: novelty, distinctness, uniformity, stability. How it is novel, as I already mentioned, distinguishable by at least one essential characteristic for which the variety has been developed. Then uniformity, it should be sufficient, the sufficient uniformity must be there for all essential characteristics, and it must be stable. The characters should not be segregated in the, in subsequent generations. And then denomination, exactly, this must be, the alphabets and numbers of a variety. I mean, that is, permissible to protect under PPBFRA. Denomination must be strong, like PVW 343. So PV of wheat, and so PVW, and that is alphabet and number also. So that is that gives the strong base for protection of that variety. And extent variety is basically tested in the different locations, 2 locations for one crop season. And if new variety is there, then in the dust testing, 2 locations of 2 crop seasons are taken. And for the farmers varieties, grower tests are essentially required. And this is basically the time frame for protection of the varieties: tree and vines 18 years and other crops 15 years. And extent notified variety, that I have already mentioned, the variety which is already notified, released, but it's not be older than 15 years. If it is more than 15 years, then it will be considered as variety of our common knowledge. Then researchers' rights, yeah, I mean, all these, the interest of the researchers have taken care of in this law. They can conduct for the experiment based on the any kind of material. They can, conduct the experiment or the research. They can develop a new variety. And if they are using as initial source of variety for the purpose of creating other variety, they must provide, the authorization of the breeder of the registered variety if they require the repeated utilization of that variety for commercialization, for commercial, development of that commercial production, right? Then they have to take permission. And then farmers are recognized as the breeder, cultivar, or conserver. And these are the different privileges for the farmers: new variety and extent variety, including farmers varieties. And then they can, reutilize or use or sow, restore, exchange their seed. Registered breeder must disclose expected performance under given condition. That is very much essentially required. If that variety fails to, perform for a particular, the giving traits or the in a particular condition, then the failure of the expected performance of for particular, the traits for which that variety has been bred, that then there is a provision of compensation to the farmers. And then rights of the communities have also been taken care of. I mean, on the whole, in a local community, they can also, claim a contribute to the contribution of the people of that particular locality or the, community in evolution or any variety, because they are also involved. They are also providing the material. So that kind of, the interest have also been taken care of. Then registered variety must be made available at the reasonable price, and that has to ensure by the licensee also, and even the breeder, because the one breeder is going to license that variety. So you have to take care of all these things all while you are going to take, the licensing agreement. Reasonable quantity, as I mentioned, protection from the initial infringement to the farmers ko freedom we have. I mean, they have given all kind of freedom to the farmers. Farmers are exempted from all kind of fees except the annual fee for renewal. And then farming community has right to reward and recognize their efforts in conservation of plant genetic resources and making those available for the future use of developing new varieties. Right now, the geographical indication, as you all know, this is basically given for the particular good which is identified in a particular area, particular region, which is originating of that good, and which is particularly manufactured also from a particular region, where it is giving a specific kind of quality kind of fragrance or the quality taste. So, and that is the reputation of or the characteristic of a particular good is essentially attributed to its particular geography. So then, I mean, it will be, taken up in the GI. These are different classes where this agriculture, different agriculture, commodities are being protected as GI. Then, yeah, these are the examples, different, the varieties, products of agriculture-based products have been registered agriculture-based products have been registered under GI. These are different varieties of, the rice or, the mango or chili, like, different regions, different in the different states. These varieties have been protected for particular states. Yeah, this is the status of GI year-wise. This file and the protection of agriculture. Basically, I'm focusing here the agriculture-based products. This is status of last 10 years. It has gone significant, the increase in number of GI protected in case of agriculture goods. Yeah, this is the biodiversity law, as I already mentioned. The major objective is conservation and sustainable utilization. Then equitable benefit sharing also is given. And then non-Indians, if they are, taking any kind of material, they have to take permission of NBA. If Indian, they have to intimate to the State Biodiversity Board. If you are going to, commercialize any product of your, and based on the genetic material which you have taken from the biodiversity. Involvement of local bodies is the decision-making body, and that is the local biodiversity management committee, which is at the block level, which is also so responsible for giving the kind of permission to the biological resources for the commercialization or the utilization of those biodiversity for commercialization. And then there is a provision of national, state, and local level for funds for the conservation of and benefit sharing, and there is in access and benefit sharing, and then IPR for prior approval based on your biodiversity or the biological resources. Then you have to take permission before getting grant of any patent. And then there are some exemption are given for the international collaborative research projects, but those projects must be fulfilling the guidelines of collaborative research projects as per the MOEF guidelines, Ministry of Environment and Forestry and Climate Change. And here the nodal agencies are there. So in case of agriculture, if you are taking any foreign collaborative research with the international organization, you have to take permission for making any agreement between your organization, government organization, or their organization from the DEER. So DEER is the nodal agency for that, and you have to take care of all these MOEF guidelines for foreign collaborative research projects. And this is basically the IP protection initiative of ICR, particularly how we have taken over the time this IPR in IPR regime, how this journey was completed, and up to what level we are here. And before independence, basically the patent applications were filed by the cotton or the jute institutions, the laboratories of India. And then first patent application was filed by IRI for plow design, right? Design patent. So it was the combined, basically earlier it was the Design and Patent Act. So for plow, this plow design was filed. And then during this period, 1950 to 95, 10 ICR institutes, they filed their own 74 applications. And then IPR cell was established in 1997, and the Joule Committee guidelines for professional service functions were, implemented at that time. And this, IPR journey was basically started in ICR from this stage. I mean, the set IPR cell was established. And then 2006, these, set guidelines were developed for the IP management, IP technology, IP management, technology transfer, and commercialization. And this is the structure in country, because from the ICR headquarters, intellectual property and technology management unit is coordinating, facilitating all IP kind of activities in the country, and even the incubation activities for generating startups or entrepreneurs based on the ICR technologies. And we are providing the technical backstopping to the entrepreneurs and startups in the different fields of the agriculture. And we have the zonal level units, and then institute level units are also, they are looking after all these IPR issues. We have set guidelines for management of these IPs. And then we have the commercial wing of ICR, that is the Agri-Unit India under Government of India Enterprises under the DARE company, which is taking care of all commercialization of technologies, of ICR based on the guidelines. And these guidelines basically revised in line of the provisions of national IPR policy. And these recently 2018 we have revised these guidelines, and all issues have been taken. This is the scenario of commercialization, technology commercialization. More than 5,000 licensing agreement have been signed for the 1,500 technologies in different areas, different zones, right? Yeah, so here is the seed and planting material is giving the highest percent share for the technologies, followed by the food processing and post-harvest technologies and pharmaceuticals. Yeah, different, and the crop science and horticulture sciences are giving, the highest number of licensing, and then a number of technologies from the engineering and fisheries. Yeah, different, varieties which were licensed in the different crops. Yeah, this is scenario of IP portfolio. Plant varieties we have submitted around 1,600, and around 1,200 varieties have been protected, and patents likewise, and more than 400 PP patents we have granted. And out of 1,500 copyright, like by design and trademark. And this is basically the 203 crop varieties have been notified. Different crop varieties have been notified by PPBFRA, under which different kind of varieties are being submitted for protection, right? Like new, extent, or farmers varieties. This is the status of registration. So far, more than 8,000 varieties have been protected under PPBFRA. Out of these, maximum number is from the farmers varieties, more than 4,000. And then this one extent varieties. And then here we can say the farmers varieties on top, then followed by private and public sector organization. Yeah. So this is total varieties which were submitted to the PPBFRA, around 20,000. Out of 20,000, 8,000, more than 8,000 have been protected. This is the status of, the crop-wise status of certification issued, means registered, number of registered varieties. So this is the end of the story. Actually, this basically this all law are basically the legal laws for the protection of your IP, your innovations, which are created by the innovator, right? And basically, in the field of now, because nowadays this, with the advancement of the agriculture research or the frontier area of the science, this, IPR is very, very much essentially required, because this is the only the legal, the legal certainty and transparency can only be, taken from these laws. I mean, IPR laws. This is basically the required for in this technological regime, where we all, regulations of plant genetic resources have been taken care of. All, regulations of biodiversity related issues have been taken care of. And then based on these, international negotiations and new regimes in this area, our guidelines and policies are being developed, reformed, renegotiated. So all these kind of, the guidelines are being developed for protection of IP. And then IPR basically allow the investors or the industry people to make long-term investments in the innovation, because when we are going to get, protection out of your creation, your innovation, then somebody cannot, take, deprive of the benefit out of the utilization of your, inventions. So with this, thank you all for, patience listening. Thank you. If you